The Objective News Network, the corruption of New Jersey's Chief Justice, Stuart Rabner, and his disciplinary review board. Hello, everyone. Welcome to our broadcast. In past stories, we've told you about the corruption of New Jersey's Supreme Court and this man, Chief Justice Stuart Rabner, who allegedly directed the fixing of several citizen complaints about a ring of lawyers, judges, and law enforcement officials who were running a racketeer, influence, corrupt organization, or RICO for short. The evidence contained in the National Investigative Library of Evidence, or NILE database, suggests that Chief Justice Rabner was determined to block any investigation of the lawyers to prevent the exposure of the RICO enterprise. Last time we showed you, using only the actual evidence, how Chief Justice Rabner and this man, Charles Centenaro, the former director of OAE, abused the Office of Attorney Ethics and the Supreme Court of New Jersey to destroy the lives and reputations of the innocent victims of the RICO enterprise who dared to lodge complaints against lawyer members of the same enterprise. As it turns out, if the charges lodged by the complainants had been properly investigated, it would have exposed the RICO enterprise, the corruption of the Rabner court itself, and the fixing of lawyer disciplinary complaints, legal cases, and the corruption of the Federal Court of New Jersey and federal judges like Lady Dunn-Wettre and Madeline Cox Arleo. In Dunn-Wettre's case, she defamed a key eyewitness in the case and then threw a legal case that threatened to expose her boss, Judge Cox Arleo, for churning cases in the direction of her husband's attorney's law firm, Arleo and Donahue, in violation of her oath to the U.S. Senate Judiciary Committee before she was allowed to take her seat on the federal bench. Here is a letter written by one of Mr. O'Keefe's attorneys, Mr. Joshua Thomas Esquire, who tried in vain to work with Judge Dunn-Wettre. In his letter, Thomas details exactly how she and her court intentionally threw the O'Keefe case in the matter of the RICO Enterprises insurance fraud and bogus billing kickback scheme. Mr. O'Keefe lost his home as the result of Dunn-Wettre's intentional fraud upon the Federal District Court of New Jersey and upon the disciplinary machinery of the Supreme Court of New Jersey. As you can read for yourself here, Judge Dunn-Wettre left absolutely nothing to the imagination as she defiled the ICM principal investigator, me, John Hnatio, outright threatened Mr. Thomas, the attorney, to drop all RICO charges and then summarily dismissed a motion to include any RICO cause of action in the O'Keefe matter. Of course, she did this to stop any possible RICO investigation that would have exposed her fraud and to protect her boss, Madeline Cox Arleo, from exposure for violating her oath to the U.S. Senate Committee on the Judiciary. After Centenaro and his underlings, Jason Saunders, Timothy McNamara, Joseph Striefler, and Stephen Harrison, published a series of fraudulent so-called investigative reports, two of the complainants, the Institute for Complexity Management's principal investigator, John Hnatio, and James O'Keefe, filed separate appeals with Rabner's disciplinary review board. The ICM appeal provided clear, compelling, and overwhelming evidence that the Office of Attorney Ethics reports were fraudulent because they intentionally did not investigate the charges made both by ICM and Mr. James O'Keefe, Jr. The complaints clearly implicated Judge Rabner, his court clerk, Heather Joy Baker, and each of the lawyers against whom charges were filed at the OAE with being members of the RICO enterprise, first reported to this man, Gurbir Grewal, while he was serving as the Attorney General of the state of New Jersey. The former chairwoman of the Rabner Disciplinary Review Board was this woman, Bonnie C. Frost, Esquire, who oversaw the despoliation of the appeals process by her subordinates to prevent any possibility of an investigation of the RICO enterprise that would expose the corruption of her boss, Rabner, the Centenaro Office of Attorney Ethics, and the Federal District Court of New Jersey, most notably Judges Dunn-Wettre and Cox Arleo. And then there's this man, Mr. Barry Petersen, a deputy counsel at the Disciplinary Review Board, working for the chief counsel, Ellen Brodsky, to orchestrate the despoliation of the appeals process with this man, Lawrence Lustberg, a criminal defense attorney at one of the largest and most prestigious legal firms in New Jersey, Gibbons PC, to prevent the possibility of any RICO investigation. Again, we are going to let only the evidence as we have it, as taken directly from the ICM Nile database, speak for itself to demonstrate exactly how the dirty deed was accomplished. At the outset of the appeals process, Mr. Lustberg was afforded the opportunity to rebut the charges and each piece of evidence provided to him by both ICM and Mr. James O'Keefe, Jr. But for unknown reasons, he apparently did not take advantage of the critical early opportunity, the right time, to defend his clients at the Callaghy law firm, Sean Callaghy, Michael Schmeichen, Samuel Saltman, and, as co-counsel, Benjamin D. Light. By this time, Benjamin Light had sought another legal co-counsel to help him defend himself at the law firm Arleo and Donahue, owned by Judge Madeline Cox Arleo's husband, Frank P. Arleo. It was not until too late in the process that Lawrence Lustberg decided that he would violate court rules to submit directly to Ms. Frost and, allegedly, other members of the Disciplinary Review Board, a highly derogatory and strictly prohibited letter that ended up despoiling the entire appeals process. Here, we are simply going to let the Lustberg letter speak for itself. As you can see, the letter to Bonnie Frost does not rebut any of the real charges made by both ICM and Mr. O'Keefe in their separate complaints to the OAE or the DRB appeal regarding the existence of a RICO enterprise. Instead, the letter is filled with misleading and outright perjurious statement and rife with personal animus against the complainants. The ICM principal investigator and O'Keefe are vilified and defamed in an attempt to sway the judgment of the DRB members prior to any quorum vote on the appellee submissions and supporting evidence. Mr. Lustberg's letter makes it clear that he failed to rebut, at the appropriate time in the appeals process, the materials contained in 3 boxes of evidence shipped directly to his attention at Gibbons PC at the very outset of the appeals process. You can view a compilation of the receipts used for maintaining the chain of evidence as part of the Nile database. This, it appears, was the motivation for Mr. Lustberg to write his prohibited letter to Bonnie Frost, the chairwoman of the Disciplinary Review Board, and all the other members of the board. This letter may represent one of the very best examples of why so many people do not trust lawyers or our legal system. It was Mr. Petersen's job to have completely stopped the appeals process, take appropriate steps to correct the bias already inflicted on the process by Mr. Lustberg, but he intentionally decided to let the already despoiled appeals process run its course, not to achieve justice, but rather to kill the appeal. But Mr. Petersen's only action was to send a letter to Mr. Lustberg telling him that she should not have sent the letter. In that letter, Mr. Petersen proclaims, after the damage has already been done, that his letter will not be considered as part of the proceedings. Lustberg was never held accountable in any way for writing his defamatory letter and intentionally despoiling the appeals process. When ONN attempted to contact Ms. Bonnie Frost to explain to us how such a thing could ever happen, she refused to talk to us. The Frost Disciplinary Review Board refused to reveal their vote count and summarily dismissed both the ICM and O'Keefe complaints, citing the remarkable claim of insufficient evidence. It is what it is for June 28, 2023. This is John Hnatio reporting for the Objective News Network. In our next story, we will talk about the fixing of the formal complaint filed against Judge Rabner, OAE, and DRB, reporting multiple frauds on the lawyer disciplinary machinery of the Supreme Court of New Jersey by members of the Rabner Court, judicial employees, and the RICO enterprise of New Jersey judges, lawyers, and state and federal law enforcement officials. Thank you. See you the next time.